Since it entered into force on June 21st, 1788, the U.S. Constitution has been amended just 27 times. In part, this is because of the difficulty of the amendment process, which requires broad agreement in both the U.S. Congress and among the states. In this video, we'll examine the process of amending the U.S. Constitution and consider why the drafters of the Constitution made it so difficult to change. Article 5 of the U.S. Constitution outlines the process for amending the document. According to Article 5, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by the conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. In other words, under Article 5 of the U.S. Constitution, the formal amendment process may begin either with a proposal passed by 2/3 majority of both houses of Congress, or a constitutional convention called by Congress upon petition by 2/3 of the state legislatures. Once the proposal is formally made through one of these two channels, Congress can choose between one of two ratification paths. It may either permit ratification by approval of 3/4 of the state legislatures, or by ratification of 3/4 of the states through state ratifying conventions. A couple of points regarding ratification are worth noting. First, Congress determines the process used for ratification of proposed amendments by selecting between ratification through state legislatures or through special state ratifying conventions. Second, Congress can also impose time limits on the ratification process, effectively setting a deadline by which the proposed amendment must either be ratified by the requisite 3/4 majority or is considered defeated. This was the fate of the Equal Rights Amendment, sometimes referred to as the ERA, which would have granted legal equal rights regardless of sex or gender. The amendment was proposed by a 2/3 majority vote of Congress in 1972 and had a ratification deadline of 7 years, or 1979. By that time, 35 states had voted to ratify the amendment, 3 short of the required 38. Interestingly, in the 2010s, several additional states voted to approve the ERA. Most recently, Virginia voted to approve the ERA in 2020, bringing the total number of states ratifying the proposed amendment to the required 38. But because the deadline for ratification had long since passed, and because several other states had rescinded their ratification in the late 1970s, the vote was largely ceremonial, and any proposal to establish a new equal rights amendment to the Constitution would legally need to begin anew with the proposal amendment process. Now, with 50 states, the 3/4 majority required for ratification means that any new proposal must be approved by 38 states, a very high bar indeed. This means that there are effectively 4 paths for amending the Constitution. A proposal made by a 2/3 majority vote of both houses of Congress and ratified by 3/4 of the state legislatures, a proposal made by a 2/3 majority vote of Congress and ratified by 3/4 of the state legislatures in special ratifying conventions, a constitutional convention called by 2/3 of the state legislatures and ratified by 3/4 of the state legislatures, or a constitutional convention called by 2/3 of the state legislatures and ratified by 3/4 of the state ratifying conventions. But while there may be multiple avenues for amending the Constitution in theory, in practice, 26 of the 27 amendments to the U.S. Constitution have been made using the first process, being proposed by the U.S. Congress and ratified by state legislatures. Only the 21st Amendment, which repealed prohibition on alcohol, used a different process, that being proposed by the Congress and ratified by 3/4 of states through special ratifying conventions. Interestingly, the process whereby the Constitution itself was drafted, a constitutional convention called by 2/3 of the state legislatures, has never been used at the national level. There have been state-level conventions to amend various state constitutions, but there has never been a constitutional convention called by the requisite 2/3 of the states to begin a process at the national level. That's not to say there haven't been efforts to do so. Indeed, more than 100 proposals for new constitutional conventions have been made by the states, but only a handful have ever garnered support from more than a handful of states. Several states have called for a constitutional convention to craft an amendment requiring a balanced budget at the federal level. Approximately 29 states have passed a proposal for a constitutional convention to require a balanced federal budget. 5 states have passed proposals calling for a constitutional convention to overturn the Supreme Court's Citizen United decision, which removed many of the restrictions on campaign spending by corporations and interest groups. And 19 states have approved a proposal for a constitutional convention to rein in the federal government. But to date, none of these proposals, indeed no proposal, has received the requisite 2/3 majority of support. Why is this? Why has there been no constitutional convention since the convention that drafted the current U.S. Constitution in 1787? There are a couple of reasons for this. First, state legislatures and the Congress are fearful that any proposed convention could be a runaway convention, which decides to move beyond the initial proposed scope and advance a wider array of reforms, perhaps even drafting an entirely new constitution. This is precisely what happened with the original 1787 Constitutional Convention, which was charged with amending the Articles of Confederation, but which instead decided to throw out the entire document and start from scratch. In a similar way, a proposed constitutional convention to establish a balanced budget, for example, could initiate much wider reforms and revisions. Second, and perhaps in response to this concern, Congress has sometimes moved to preempt proposed conventions and to propose amendments themselves, allowing them to control the proposal process. This has occurred several times when proposals for constitutional conventions have neared the requisite threshold. The 27th Amendment, for example, was proposed by Congress when it was within final 2 votes for a constitutional convention being called. Similarly, the 17th, 21st, 22nd, and 25th Amendments were all proposed by Congress after an upswell in support from state legislatures. Article 5 of the Constitution, the article which specifies the process of amending the document, also contains 2 limitations. Specifically, the second part of Article 5 maintains that no amendment which may be made prior to the year 1888 shall in any manner affect the first and fourth clause in the 9th section of the first article, and that no state without its consent shall be deprived of equal suffrage in the Senate. But what exactly does this mean? The latter part is fairly clear. Under Article 5, no amendment to the U.S. Constitution can deprive any state of equal suffrage or representation in the U.S. Senate. This means that the constitutional provision providing each state with 2 senators cannot be amended. But what about the first provision, that no amendment may be made before the year 1888 to Article 1, Section 9, Clauses 1 and 4 of the Constitution? What did this do? Put simply, it protected the institution of slavery from being challenged by the government. Article 1, Section 9 of the Constitution outlines the powers denied to Congress. Clause 1 specified that the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1888, but a tax or duty may be imposed on such importation not exceeding $10 for each person. This clause, in other words, prevented the U.S. Congress from imposing limits on the slave trade either directly or through the use of tax measures intended to discourage this practice. Clause 4 also limited the powers of the federal government by restricting its ability to impose taxes. Specifically, Clause 4 read, "No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken." This provision, in other words, prevented the imposition of income taxes or other kinds of direct taxes by the federal government on the people. This clause was overturned by the 16th Amendment, which established the national income tax. Given the wide number of limitations imposed on the process, it's no wonder that the Constitution has been amended only 27 times since it was drafted. There have been hundreds, perhaps thousands, of proposals by individual members of Congress or state legislatures, but few have garnered enough support to make it to the agenda. Of particular interest might be 6 amendments that have passed the formal proposal stage, the first part of the amendment process, but which were never ratified. These 6 unratified amendments were the Congressional Apportionment Amendment, proposed in 1789, which would have imposed limitations on the size of congressional districts, requiring one representative in the House for every 50,000 people. Had this amendment passed, the current House would have been more than 6,000 representatives in size, a massive increase from the 435 we have today. The Titles of Nobility Amendment, proposed in 1810, would strip U.S. citizenship from any citizen that accepted or held a title of nobility in a foreign country. The Corwin Amendment of 1861 would have protected domestic institutions of slavery from any action by the federal government, effectively maintaining slavery in perpetuity. The Child Labor Amendment of 1924 would have empowered the federal government to limit, regulate, or prohibit child labor. The Equal Rights Amendment of 1972 would have guaranteed the protection of equal rights and prohibited discrimination on the basis of sex or gender. And finally, the District of Columbia Voting Rights Amendment of 1978 would have treated Washington, D.C. as a state for purposes of congressional representation and for representation in the Electoral College. But what of the successful amendments? Most of the amendments to the U.S. Constitution can be grouped into specific historical periods, often reflecting the contemporary challenges of the time. The first is the period immediately after the drafting and ratification of the Constitution itself, when the Bill of Rights, the first 10 amendments to the U.S. Constitution, along with the 11th and 12th amendments were passed. We explore the Bill of Rights in another video. The 11th Amendment established sovereign immunity for states, protecting them from lawsuits from non-state residents, and the 12th Amendment provided for the joint election of the president and vice president, rather than selecting the runner-up as vice president, resolving a tension that emerged with growing power of political parties in the country. After the passage of the 12th Amendment in 1804, the Constitution stood unamended for over 60 years. But following the Civil War, 3 amendments, collectively referred to as the Civil War Amendments or the Reconstruction Amendments, were passed. These amendments and the broader historical period represented such a profound change that this period is sometimes referred to as the second founding of the U.S. government. Specifically, the Civil War amendments include the 13th Amendment, which abolished slavery and involuntary servitude except as punishment for a crime. The 14th Amendment, which is one of the most important and consequential constitutional amendments and guarantees the right of citizenship to all persons born in the United States, as well as establishing the principle of equal protection under the law. And the 15th Amendment, which guarantees the right to vote regardless of race, color, or previous condition of servitude. The next period of amendments was the Progressive Era, which lasted from around 1890 to around 1920. During this period, the United States was undergoing a period of profound political, economic, and social change. The Progressive Era amendments were intended to address these changes. The 16th Amendment permitted the imposition of a federal income tax, significantly expanding the funding base and thus the power of the federal government. The 17th Amendment established the direct election of senators, overturning the selection of senators by state legislatures, a process that was increasingly viewed as corrupt and illegitimate. The 18th Amendment, known informally as the Prohibition Amendment, prohibited the sale, manufacture, and transportation of alcohol in the United States. And finally, the 19th Amendment expanded the suffrage by granting women the right to vote. The 1960s, sometimes called the Second Progressive Era, saw a number of additional amendments to the U.S. Constitution. Again, this was a period of profound political and social change as the struggle for civil rights and the expansion of social welfare spending combined with the anti-war movement opposing U.S. involvement in Vietnam. Constitutionally, this period produced 4 amendments. The 23rd Amendment granted Washington, D.C. electors in the Electoral College as though it were a state. The 24th Amendment outlawed the use of poll taxes to restrict the right to vote. The 25th Amendment clarified the line of succession to the presidency and the process whereby a vacancy in the vice presidency would be filled. And the 26th Amendment lowered the voting age to 18 years old. And finally, there were a handful of amendments that did not fall neatly into any one of these historical periods previously considered. This includes the 20th Amendment, ratified in 1933, which changed the dates of the presidential and vice presidential terms and those of Congress, reducing the lame duck period. Before the 20th Amendment, federal elections would occur in early November, but the new terms of office would not begin until early March. The 20th Amendment moved the start date for the new terms of Congress and the presidency to January 3rd. The 21st Amendment, also ratified in 1933, repealed the 18th Amendment and ended prohibition in the United States. The 22nd Amendment was proposed in 1947 and ratified in 1951 in response to the election of Franklin Delano Roosevelt to an unprecedented 4 terms as president. Before Roosevelt, the tradition established by George Washington was that presidents would only serve 2 4-year terms. The 22nd Amendment was codified that tradition, limiting presidents to a maximum of 2 4-year terms. And finally, the 27th Amendment limits Congress's ability to pass salary increases for themselves by delaying any salary changes passed by one Congress until after the next election. The 27th Amendment has the distinction of being the amendment that took the longest time to ratify. It was originally proposed in 1789, but was not ratified until 1992, a delay of over 200 years. In addition to thinking about the historical evolution of the Constitution over time, we can also consider the various amendments by subject matter. The Bill of Rights and the 13th and 14th Amendments all deal with the problem of securing basic rights and liberties. The 15th, 19th, 23rd, 24th, and 26th Amendments all center on the question of the right to vote. The 12th, 17th, 20th, 22nd, and 25th Amendments all deal with questions surrounding elections and terms of office. The 18th Amendment established prohibition, and the 21st overturned it. And finally, the 11th, 16th, and 27th Amendments all address questions or problems with essentially centered on limiting government functions. So far, we've considered the formal amendment process used to update or change the U.S. Constitution. But the Constitution has also changed over time due to a variety of informal practices that lead to different interpretations or practices resulting from the same text. Perhaps the most notable or important of these informal changes was the adoption of the idea of judicial review by the courts. Nowhere in the Constitution does the concept of judicial review appear. Instead, the courts claimed that power for themselves in Marbury v. Madison's decision in 1803. We examined the power of judicial review in another video if you're interested in learning more. Congressional legislation has also played a role in establishing informal changes to the Constitution. The Judiciary Act of 1789, for example, established the federal court system. Similarly, changing interpretations of the Commerce Clause have dramatically expanded the power of the Congress. The power of the presidency has also increased dramatically without any formal changes to the Constitution. For example, while the Constitution grants the president the power to serve as commander-in-chief and reserves the power to declare war for the Congress, in practice, the president has used the power as commander-in-chief to engage in military actions abroad without a formal declaration of war. This represents a departure from the strict text of the Constitution. Changes in the practice of politics have also led to different interpretations of the Constitution over time. An example of this might be the establishment of political parties, which are not found in the Constitution, but which today play a critical role in the functioning of Congress, the electoral process, and countless other areas of governance and politics. And finally, customary practices have also served as informal rules governing political behavior outside the Constitution. An example of this might be the 2-term limit on presidents that existed before FDR's 4 terms previously discussed. But that's it for now. If you found this video helpful, check out the other videos in this series. Please leave any questions you have in the comment section below, and thanks for watching. Goodbye.